development and the financial development of the country. More developed you are, less deduction, disallowance you make. Less developed you are, more disallowance you make. And that is the barometer in the world everywhere. Scientifically a study was conducted and they found Afghanistan allows only 10% of interest because they are backward absolutely, lowest ebb of the curve. Look at Denmark. Denmark says 75% should be allowed, only 25% should be disallowed. And we say 30% should be disallowed, anything more than 30%. We are better, more developed than Denmark? Is a question by itself. When the developing countries are trying to, the development index of the world is available, there are countries which allow 93%, 87%, and a country like Denmark which allows 75% of interest as a deductible and only 25% is considered. India is worse than even Denmark, and therefore this rule requires a reconsideration. For honestly speaking, country at the development stage should not go into the thin capitalization rules. If your tummy is full and some food is offered to you, you reject that. But if you are hungry and food is offered to you, do you think that you should reject that? Answer is no. Unless you follow a particular type of a food and you don't get that food, then you can reject. That's a different story. And therefore, underdeveloped countries generally do not follow thin capitalization rules. This is what author who did a wonderful study on the subject on thin capitalization and the financial development in the world. One Mr. Mohammad Matan, whose working paper is available also on the website, has said in the very clearly written statistics that thin capitalization is not warranted for a country like India. Recently, while debate is on in UK, somebody who was very interested in India also saw the debate going on in UK, and number of people answered the questions. While answering the question, he gave a view that look at India, they brought in the thin capitalization. In my opinion, and he gave reasons that in my opinion, India should desist themselves from introducing thin capitalization rules because India needs capital. Introducing such complex rules that impacts on international trade and investment requires provision that demonstrate that India is in a competitive place of business. Are we in a competitive place of business? Answer is clearly no, and therefore thin capitalization in a country like ours is premature, too much early, and therefore just because fashion is going on in the world that we must change the laws, we must change the international tax related provisions because it is liked by people like sitting here on a dais. We should not do that. No, because Mr. Nilesh Kapadia is an LLM from VIA University. So he definitely likes all international developments also should be taught here. Teaching is understanding. Implementation, in my opinion, should be desisted. Correct. Again, let me tell you, friends, the non-discrimination article of the double taxation avoidance agreements can be invoked even for thin capitalization. When you pay similar type of a situation interest on a borrowing within the country to your associated enterprise, South Africa, SA Builder Supreme Court says interest, without interest payment also borrowing can be given, lending can be given to the subsidiaries. So therefore, in the Indian context, interest if it is not charged, understand. Can you therefore compel a foreign company to have the disallowance on account of payment of interest to the foreign company? If you make the payment of interest to the domestic company, no disallowance can be made. How can you make the disallowance in the case if the foreign company or associated enterprise you have paid the interest? A most important issue arises. Where the guarantee commission paid to a foreign enterprise, in my opinion, that is definitely an interest because our definition of interest under section 218 clearly says guarantee commission is nothing but an interest, and therefore that also will be calculated for the purpose of calculating disallowance. The law says if you borrow on the basis of implicit or explicit guarantee from the parent or associated enterprise, lot of research on the subject of implicit guarantee. I could not find this word appearing in the Google. There is an implicit support is there, but explicit guarantee could be there. What is implicit support and what is implicit guarantee? Let's understand. We have a decision of GE Capital from Canadian Supreme Court, which has dealt with this subject. What is implicit guarantee and what is implicit support? Not what is implicit support. Let me read out some of the passages from there. The concept of implicit support has been discussed in GE Capital. Implicit support is an assumption. This is very important. Implicit support is an assumption that the parent would not permit its subsidiary to become insolvent, and with or without the guarantee, the parent would be expected to take actions to protect the subsidiary's creditworthiness in order to, and amongst other things, protect the parent's investment and its own good name and reputation. To put your reputation at the safeguard, you have told moral obligation that yes, I will ensure that my subsidiary meets your obligation of payment of interest. Does it amount to an implicit guarantee? Or even you have not said something like that. Generally, in international jargon, it is known as a letter of comfort versus guarantee. Letter of comfort is considered to be an implicit support. Implicit support whereby a parent ensures that subsidiary's functionality is continued without any disturbance and without any suffering of reputational risk, and therefore you give that comfort is available to the person who is lending. And if that is considered to be implicit guarantee, I think it is totally mistaken. Guarantee is a contractual obligation. Moral support is not a contractual obligation. Somebody has accepted my moral support. Does it mean that I am morally obliged? There are examples in the world. People have said moral support, but the companies have gone bankrupt and the parents have not supported those bankrupts. Their obligations have been done away. So in such a situation, how do you compare implicit guarantee with an implicit support? And therefore, implicit guarantee is only an oral thing, whereas explicit guarantee is a contractual obligation. So therefore, to include this term in our regulation, implicit support, therefore, if you look at further last paragraph, implicit support can also be assumed where the entity is able to take loan beyond its standalone creditworthiness due to creditworthiness of the entity, of the parent, or of the group, multinational group as a whole. And therefore, this is a clear-cut case where needs the clarification, where we need clarity, and in absence of clarity, it is bound to create huge amount of litigation in the country, and this is another challenging factor which must be considered. Discrimination clause, in my opinion, definitely will apply, and therefore non-discrimination clause, and therefore you will be able to track the tax department. Now, if you are a resident, can you apply non-discrimination article for your transaction with a foreign enterprise? We have direct decision supporting this. Herbalife decision of a Delhi tribunal confirmed by the Delhi High Court says in a transaction between resident and non-resident, discrimination provisions will apply. And therefore, it was a case of an Indian company making payment of some royalties and fees for technical services, and the TDS was not done. And the domestic transaction, there was no TDS, and therefore Chidambaram brought in on the domestic transactions of the TDS. And if you do not get a TDS, it is disallowed now. And therefore, this was a case where the discrimination was in existence, and hence the discrimination article, in my opinion, can be successfully argued in this particular case. Friends, I think I should sum up today with these two subjects only, because these are the two most important subjects. There are some important items in the budget, like foreign tax credit related to MAT and foreign tax credit in the dispute, indirect transfer pricing provisions, which is very well known to all of us, offshore fund, which has not kicked up, not started in India. There are fund managers sitting in India, it has not taken up. So where is the question? You go on making any amendments, as many amendments as you want. No foreign funds managers will come and sit in India. You give them the red carpet treatment, nothing will happen. There are amendments related to rupee denominated bonds which are called as masala bond. Capital gains are exempted. Interest is subject to withholding tax which is lower 5%. So at times now you can see borrowing from any country, applying the domestic law is better than applying the treaty provisions, because India's tax treaties have minimum 10% except from 1st April 2017. Mauritius treaty will have 7.5% tax withholding on the interest payment. Otherwise, our law says only 5%. As far as section, the term not defined in the Income Tax Act can be now defined, can have meaning as per the definition, as per the explanation given by the Income Tax Department. Explanation is what? By circular. Earlier it was by notification. They have changed it to by circular. It means they have dispensed with the requirement of notification, but then administratively they can issue any circular defining any term. But nevertheless, whether you bring in the law or by notification, it amounts to your obligations which are violating the treaty practices, and therefore this is a clear case of a treaty override, and therefore the provisions can be easily challenged, and the such challenges are pending in the High Court. And particularly the dispute was on the term maybe. What do you mean by maybe taxable? And Bombay High Court has admitted a rate in the case of SRI, and therefore we will see what happens in those particular, because constitutional challenges can be done only in the High Court and the matter is pending. Honestly speaking, this amounts to clearly overriding the treaties by amending the domestic law to suit your own convenience, which is illegal, which is not permitted. And we have a direct decision on this subject from Supreme Court of Canada, Queen versus Medford, wherein they have said such an amendment is not permitted. So Canada brought in interpretation law, separate enactment to interpret the tax treaties. Thank you very much. I do not propose to take place of effective management and GAR, which is very dear to your heart. At some time later we will take it. Thank you.
Various issues that are there in the finance 2017, and very strong points of representation that is to be made. And ECS is probably become all those points for representation, and because the other organization also to pick up these points to make a stronger representation. Otherwise, we have another couple of litigations, and which is actually not something that is actually in fact going away from the use of doing business to a certain extent. Just if you don't mind, we can have two questions from the floor. We can have two questions from the floor. And your time is just. And any questions from the floor? Yes,
I will take this opportunity to ask one question on the secondary engagement. Whether the amount which is to be debited to the associated enterprise, can it be also mentioned as being debited with their rents, so that will not be double and then be triple taxed?
Possible. Possible. SAR, GAR, deemed dividend, and this adjustment and the secondary adjustment, everything possible. Given a situation in India, we examined that aspect. We felt that I would not go into the details of those controversies. Yes, it is possible.
But in your opinion, what are the chances of this being dropped? Because somebody who was very eligible to actually, he mentioned that perhaps actually did not have right to read the Bible.
Which is not the first time. Every time it happens.
So maybe some self will prevail upon me.
I wish what you are saying will come true. I will be delighted to see that. But I don't think this is the government with the adamant interest.